Next, on American History TV, law professor Gabriel Chin discusses whether the initial intent of the 1965 Immigration Act was to diversify America, or if it was an unintended consequence. Professor Chin argues that despite much racial tension in 1965, lawmakers at the time knew a much more diverse America was inevitable. The lecture is part of a two-day symposium hosted by the U.S. Capitol Historical Society on the history of immigration. It's about 40 minutes.
Our next speaker is Gabriel Jack Chin, who is a professor of law at the University of California at Davis. Jack specializes in both criminal law and immigration law, and I think as this conference unfolds, we realize that there is a great and sad connection between criminal law and immigration law in a variety of ways. I'm not sure how much he will touch on that today. Jack did his undergraduate degree at Wesleyan and then a law degree at the University of Michigan, and then went on to do an advanced law degree at Yale, being, if I could paraphrase President Kennedy in this in this context, having gotten a Michigan education, he then went on to get a Yale degree so that he could be a success in life, which is, of course, what President Kennedy said when he was given an honorary degree at Yale. Jack has just recently co-edited a book, or co-written a book, I guess, on the 1965 Immigration Act, which is what he's going to talk about. And I'm not going to say any more because he can tell us all about it.
Thank you, Paul, for the introduction, and thanks so much for organizing the conference. Thanks also to the Capitol Historical Society. I am going to talk today about the Immigration and Nationality Act amendments of 1965, and I have two propositions for you about the act, one controversial and the other uncontroversial. I will begin with the uncontroversial one, and that is that the Immigration and Nationality Act amendments of 1965 were the most effective civil rights legislation since Reconstruction. Now, I admit that the Civil Rights Act of 1964 was important, but more than 50 years after its passage, the situation of African Americans and other minorities with respect to employment, with respect to education, with respect to wealth and health, still is far, far from that enjoyed by whites. The Voting Rights Act of 1965, also revolutionary and important. It also dramatically changed the political situation in many parts of the country, but 50 years after its passage, some parts of it have been held unconstitutional by the U.S. Supreme Court. Other parts are at grave risk. And again, 50 years after passage of the Voting Rights Act, voter suppression in the states is alive and well. So these laws were landmarks, very important, but they worked only in part. By contrast, the Immigration and Nationality Act amendments of 1965 were completely successful. They were designed to bring race neutrality to the immigration stream, and they did so. Before 1965, a supermajority of the immigrant stream was Caucasians from Europe. Since 1965, a supermajority of the immigrant stream has been Asian, Latino, Africans, and other non-whites from around the world. One important contributor to the passage of the 1965 Act was the late John F. Kennedy's posthumously published book, A Nation of Immigrants, published in 1964 with an introduction by Robert F. Kennedy. The nation that he imagined in that book, where immigrants were admitted not based on race, but based on individual characteristics, such as connections to people in the United States or skills that were valued by the United States economy, is on the verge of coming to pass. California, Hawaii, New Mexico, Texas, and the District of Columbia are majority-minority jurisdictions, and the United States as a whole, thanks to the changes in law and policy wrought by the 1965 Act, is expected to be majority-minority by 2043. It's also clear, at least to me, that the 1965 Act attacked entrenched racism in the same way that the Civil Rights Act and the Voting Rights Act did. Racial selectivity in the immigration area began with the Chinese Exclusion Act of 1882. And it is evident from the legislative history that racial considerations, not, say, economic or political considerations, were paramount. In supporting the act, Senator Miller of California explicitly appealed to notions of racial inferiority. He said, "It is not numbers that are needed, quality is more important than quantity. One complete man, the product of free institutions and high civilization, is worth more to the world than hundreds of barbarians. Upon what other theory can we justify the almost complete extermination of the Indian, the original possessor of all these states? I believe that one such man as Newton or Franklin or Lincoln glorifies the creator of the world and benefits mankind than all the Chinese who have lived, struggled, and died on the banks of the Wang Ho." Opponents of Chinese exclusion in 1882 quoted the famous line from the Declaration of Independence: "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness." Supporters of Chinese exclusion had a powerful response to this argument. Senator Grover, for example, pointed out that our conduct towards the Aborigines of this country, whom the founders discovered in lawful occupancy here when they came, must be construed as fixing a limit to the meaning of their public declarations upon the rights of man. When they declared that all men were created equal and were endowed by their Creator with the inalienable right of life, liberty, and the pursuit of happiness, they undoubtedly meant all men like themselves and in like manner joined in the bonds of civil society. And when they dedicated this country to be an asylum for the oppressed of all nations, they undoubtedly meant all nations whence they came, people of character and conditions similar to their own. There was an explicit connection in this period between racial policy with respect to Indians, Asians, and African Americans. Senator Jones, for example, argued in 1882, "Does anybody pretend to tell me that it is a blessing to this country that African Americans are here? It is no fault of ours that they are here. It is no fault of theirs. It is the fault of a past generation. But their presence here is a great misfortune to us today. And the question of the adjustment of the relations between the two races, socially and politically, is no nearer a settlement now than it was the day Sumter was fired upon. What encouragement do we find in the history of our dealings with the Negro race or in our dealings with the Indian race to induce us to permit another race struggle in our midst?" Congress found these arguments persuasive. As the great historian Oscar Handlin explained, by the end of the 19th century, the pattern of racist practices and ideas seemed fully developed. The Orientals were to be totally excluded, the Negroes were to live in a segregated enclave, the Indians were to be confined to reservations as permanent wards of the nation. The White America policy was deep in the law. The Naturalization Act of 1790 was signed by Washington as president, John Adams as president of the Senate, and Thomas Jefferson as Secretary of State. It limited the privilege of naturalization to free white persons, a policy that remained in effect in one way or another until 1952. In 1922, a litigant appeared in the Supreme Court with a non-white litigant with a pretty good argument that as the law was drafted, there was a loophole that maybe allowed him to naturalize. A certain category of people of color could become naturalized citizens, but the court rejected that argument based on the strong policy of racial restriction. A unanimous court called the white naturalization policy a rule enforced from the beginning of the government, a part of our history as well as our law, welded into the structure of our national polity by a century of legislative and administrative acts and judicial decisions. And as a question of interpreting the intent of Congress, the court was clearly right. The policy of Chinese exclusion that began in 1882 was extended to other Asian racial groups over time. Africans, Jewish immigrants, Catholic immigrants were discouraged not explicitly by race or religion, but by gerrymandering designed and implemented in the national origins quota system. Therefore, by 1965, it can be said that the body of law that the 1965 Immigration Act ripped out by the roots was an integral part of U.S. racial policy. So that's the uncontroversial claim, at least in my mind, and that is that the 1965 Immigration Act was an amazingly successful civil rights law. Here's the controversial claim. Many very thoughtful scholars and commentators have looked at the development of the 1965 law and concluded that the diversification of the immigrant stream that resulted was an unintended consequence. It was completely accidental. It was unwelcome. The law was not intended to make any substantive change in the white demographics of the immigrant stream. So Erica Lee wrote, "The 1965 Act abolished the national origins quotas, but lawmakers still expressed a desire to facilitate immigration from Europe and to limit, or at the very least discourage, immigration from Asia, Latin America, and Africa. Indeed, although a racial hierarchy was not explicitly written into the law as in 1924, it remained deeply embedded in the 1965 Act's design and intent." May Nye concluded that liberals, even liberals in Congress, believed that opening Asiatic immigration in principle would not mean opening it in practice, at least not significantly. Hugh Davis Graham said that the people who passed the law believed that far from threatening to ethnically transform the nation, the immigration reform bill would, as a practical matter, produce a national origin system of immigration, but without the offensive quotas. Theodore White called the 1965 Act noble, revolutionary, and probably the most thoughtless of the many acts of the Great Society. Roger Daniels claims that if Congress had fully understood the Act's consequences, it would not have passed. My controversial claim is that this is not the best view of the evidence, that Congress understood that when it passed the law in 1965, it was putting U.S. immigration policy on a genuinely race-neutral basis, and the chips would fall where they may. I have several kinds of evidence for this. The first is votes in Congress. With my colleague Doug Spencer at the University of Connecticut, I've done an analysis of the 1965 bill based on roll call votes, and we think that we have demonstrated that the Immigration Act is a close cousin of the Civil Rights Act and the Voting Rights Act. Even though there was an election in 1964 between the Civil Rights Act and the other two acts, 196 individual representatives and 61 individual senators voted yes on all three bills. Of the roll call votes in the 89th Congress, which sat in 1965 and 1966, the one that matched up most closely with the Immigration and Nationality Act with respect to the individual votes for and against was the Voting Rights Act. Social scientists have developed tools to evaluate members of Congress based on their right, left, and racial ideology views, looking at their career voting records. And based on these measures, virtually the same ideological coalitions supported and opposed all three measures. Another important vote in Congress was on the Immigration Act of 1990, which increased the number of visas available for family-sponsored and employment-based immigration. The racially diversifying effects of the 1965 Act were known by the time the 1990 Act was on the table. Even though Congress knew in 1990 that increasing the number of visas would mean increasing the number of non-whites in the immigrant stream, Congress made that decision. Now, there was a Democratic majority in both houses of Congress in 1990 as in 1965, but I think it's perfectly plausible to claim that the 89th Congress was at least as civil rights oriented as the 101st Congress, and therefore that Congress in 1965 would have been as untroubled by more non-whites in the immigrant stream as they were in 1990. So I think there's good reason to think that the Voting Rights Act and the Civil Rights Act were genuinely anti-racist bills. They were not modern civil rights bills as we would understand them today. The anti-gay animus is clear in those bills as it is in the 1965 Immigration Act, for example, but they were anti-racist, and so this part of my argument suggests that being a close cousin of the Voting Rights Act and Civil Rights Act allows the inference that the Immigration Act was not hypocritical. The second piece of evidence that I offer to you is that in 1965, for the first time in the immigration context, anti-racism, race neutrality, was an explicit rationale for the winning side in the debate. Edward Kennedy argued that the national origins quota system was contrary to our basic principles as a nation. Representative Paul Krebs said, "We must learn to judge each individual by his own worth and by the value he can bring to our nation." These kinds of arguments had been almost completely absent from previous debates in Congress over, even when Congress was liberalizing the laws slightly. The two major reforms before 1965 were in 1943, when 105 Chinese were allowed to immigrate, and in 1952, when naturalization was made race neutral and every country, including Japan, was allowed at least a token number of visas. But the 1943 and 1952 laws were explicitly, self-consciously war measures. They were pragmatic reforms. And even with respect to that, one of the most amazing things to me about these laws is that they didn't go far enough even to achieve their geopolitical goals. So in 1943, for example, 105 Chinese were allowed to immigrate, and somebody said, on the floor of Congress said, "Hey, Indians are our allies too, and winning World War II seems pretty important, so why don't we just let 100 Indians in also?" And the answer was, look, we have a very important policy of racial restriction, and we're not going to let Indians in. So the move to let Indians in failed, even to help win World War II. So in 1943, almost nobody in the majority, in the winning side, said anything unkind about racism in principle. Senator McCarran in 1952 said, for example, "We just have to be realistic and recognize that there are some indigestible blocks of people in the United States." In 1965, many members of Congress argued that racism has no place in American law. In 1952, Senator McCarran, I think accurately, said that a push for racial equality would be the kiss of death to the limited reforms that restrictionists in Congress were willing to allow to go forward. So in 1965, we have explicit anti-racist rationales articulated by the winning side. That's something new, and I think it's significant. The third point is that there was a lot of evidence at the time that people knew that demographic change was likely as a result of the law. I get this from legislative history and contemporary media reports that taking out racial restrictions, taking out racial gerrymandering would in fact lead to racial diversity. So again, Edward Kennedy said, "The people who comprise the new immigration, the type which this bill would give preference to, are relatively well-educated and well-to-do. They are familiar with American ways." He knew there was going to be new immigration. Media reports were also to the same effect. In a book from 1963, which just predates the serious debate on this law, former Congressman and future federal appellate judge Marion T. Bennett wrote a book called American Immigration Policies. And when he discussed immigration reform, he said, "China and India would ultimately be the European successor to our immigration largesse. The 1961 Indian census reported 438 million people in that country. In 1962, President Kennedy said there were 650 million people in communist China alone. The possibility that they might not take advantage of relaxed immigration restrictions is remote. In 1965, U.S. News & World Report published an article called "A New Mix for America's Melting Pot," and they reported, under rules just approved by Congress, officials forecast these changes in the flow of immigrants to the U.S. From Asia, many more immigrants expected since racial restrictions on Indians and Orientals are wiped out. Nobody has estimated the number of Chinese who will apply to enter the U.S., the magazine reported, but the potential is large. The Christian Science Monitor said that the new law would contribute to a multinational and multiracial United States. The Los Angeles Times reported, "What is ahead is an even more diverse mix of populations, favoring the Italian, Spanish, and Greek, becoming to the Latin American, inviting the Oriental and African. When we add to this the rapid rise of the native Negro population, we see at once that we will have much more of what President Kennedy called the pluralistic society." Even the exceptions often support this rule. In 1966, the American Legion had come to the conclusion that they would not oppose the bill, and in a 1966 article in the American Legion magazine, they explained why. They said there's not going to be any change in the demographics of the immigrant stream. But then they said that all of the articles in the lamestream media, which suggest that there's going to be dramatic alteration in the sources of immigration, are a bit of faking. Congress understood the structure of this law had two main sources of immigration: family-sponsored immigration, that is, relatives of U.S. citizens or lawful permanent residents, and employment-based immigration, that is, people who had certain kinds of skills that were desired in the United States. Those were the two main sources of visas for people who might want to come here, and the record was clear in Congress that Congress understood that non-whites would take advantage of both of these sources. Robert Kennedy, for example, testified as Attorney General in favor of the bill about the problems Americans had in bringing in an immediate relative who was, quote, Italian or Australian, Spanish or Portuguese, Japanese or Korean, Indian or Filipino. So white ethnics were certainly on the list, and I don't think that there's any question that Italians and Eastern Europeans were very, very important politically to get this bill on the radar screen and get it through. But people understood at the time that they would not be the only beneficiaries. As for employment-based immigration, there had been a 1962 law that offered special incentives for engineers to come to the United States, and this was created as an exception to the quotas. And so Asians and others could come under this law without respect to any sort of quota limitations. As one scholar wrote, because of this 1962 law, immigration of European engineers increased by 23%, but that of Asians increased by 182%. This indicates that skilled Asian immigration has a remarkably high elasticity with respect to a moderate liberalizing of the restrictions. And the statistics on this 1962 law were before Congress when they made its decision. So my argument is not that Congress should have known what is obvious in retrospect, and that is that once we reduce racial restrictions or eliminate racial restrictions, then different people are going to come to the United States than came before. My argument is that Congress actually did know that, that racial diversification was going to be a consequence of their law. Now, I don't mean to suggest that the many people who disagree with my view are just ignorant. There is some contrary evidence, and I will talk with you about it, but I don't think it's compelling. The most prominent piece of evidence that there would be no demographic change, at least with regard to Asians, is a 1964 prediction by Attorney General Robert Kennedy testifying in a committee. And as described by Fortune magazine, Attorney General Robert Kennedy told the Senate that 5,000 Asian immigrants might come the first year after which immigration from that source would virtually disappear. And the after which immigration from that source would virtually disappear is a quote. It's an accurate quote from Robert Kennedy in 1964. Scores of media articles and academic books and journals cite this testimony as evidence that Asian immigration was expected to go down as a result of the 1965 Act. And this is a complete misinterpretation of the technical issue that Robert Kennedy was testifying about. He was testifying about the interaction of two special rules. Between 1924 and 1965, because of the Monroe Doctrine, Western Hemisphere immigration was numerically unlimited. As many people from the Western Hemisphere as wanted to come to the United States, to put it more starkly in connection with current immigration policy debates, as many Mexicans as wanted to come to the United States could come to the United States with absolutely no numerical limitation. There were other kinds of economic and health restrictions, but no numerical limitation of qualified immigrants. However, to prevent the immigration of Asians, there was a special Asian racial attribution rule that all people of Asian racial ancestry, wherever born, wherever they were a citizen, were charged to the quota of their racial homeland. And so the way these rules worked together was that if we had a native citizen and resident of Brazil who was of German ancestry, that person was treated as a Brazilian, and like all other Brazilians, could come to the United States without numerical limitation before 1965. If we had a native citizen and resident of Brazil who was of Japanese racial ancestry, that person was treated as Japanese and could come to the United States if and only if one of the 100 visas that were allocated to Japan every year happened to be available. Robert Kennedy was saying that elimination of this racial attribution rule would mean that some people of Western Hemisphere citizenship but Asian racial ancestry would be able to take advantage of the special rule. And 5,000 of them would come from the Western Hemisphere to the United States if the rule passed. He was not saying that worldwide Asian immigration would be 5,000 people a year, as many media sources have wrongly claimed. Asian immigration in 1964 was over 21,000. It had averaged 15,000 per year in the 1950s. So to say that 5,000 would come after the 1965 Act came into effect has to be wrong. So the most dramatic piece of evidence that there was expected to be no change in the demographics of the immigration stream turns out to be a misunderstanding of a very complex piece of law. The best evidence that members of the administration or Congress thought that there would be little non-white immigration are public statements of three knowledgeable participants: Emanuel Seller, Japanese American Citizens League President Mike Masaoka, and Secretary of State Dean Rusk. Emanuel Seller, obviously a prime mover of the bill, very important in immigration for half a century, said the following: "Mr. Chairman, claim has been made that the bill would bring in hordes of Africans and Asians. This is the answer to that false charge. Persons from African and Asian countries would continue to come in as heretofore, but would be treated like everyone else. With the end of discrimination due to place of birth, there will be shifts to countries other than those of Northern and Western Europe. Immigrants from Asia and Africa will have to compete and qualify in order to get in, quantitatively and qualitatively, which itself will hold the numbers down. There will not be, comparatively, many Asians or Africans entering this country. Mr. Chairman, since the peoples of Africa and Asia have very few relatives here, comparatively few could immigrate from those countries because they have no family ties to the United States. There is no danger whatsoever of an influx from the countries of Africa and Asia." Mike Masaoka, a longtime Japanese American Citizens League officer and longtime advocate for immigration reform, insisted that fears of a flood of immigration from the Orient were groundless. because 74% of the visas were reserved for family reunification. He agreed with Emmanuel Seller that the small number of Asians who were already in the United States would be unlikely to take advantage of them, with the result that, quote, the general pattern of immigration which exists today will continue for many years yet to come. Secretary of State Dean Rusk, involved in this bill for a long period of time, commented, any increase in the volume of immigration resulting from the proposed amendments would be rather limited against the actual volume of Asian immigration into the United States between 1953 and 1963. So what do we make of these? Maybe these were evasions designed to get a bill passed. I'm not from Washington, D.C. Many of you are. Does anyone ever say anything less than the full truth when they're trying to get a bill passed? Is that legal? Can they do that? So that's a possibility. Maybe these were honest predictions that turned out to be wrong without being essential assumptions without which the bill wouldn't have passed. What I want to say is that in the context, I want to propose that in the context of the bill, in the context of the discussion, they were sincere claims and they have proved to be accurate. What is it that constitutes an influx or a flood? Mike Masaoka, for example, argued that even if all the 1 million people of Asian descent from Latin America came in at one time, they still would not equal the number of Asiatics in this country, and the total number of Asiatics in this country is less than 0.5%. So the doubling of a tiny number is still a tiny number. Robert Kennedy argued that an increase of 2% in the Italian-American proportion of the total U.S. population over a course of years wouldn't constitute an alteration of the ethnic makeup of the country. I think the evidence that demographics was not a huge concern was suggested by the limited firewall that the bill did create, and that was the per-country limitation. As Edward Kennedy explained, the bill will not inundate America with immigrants from any one country or area or the most populated and economically deprived nations of Asia and Africa. No country can be given more than 10% of the annual total quota. So in the original 1965 bill, continuing this day, to this day in the law, are per-country limitations so that no one country, regardless of its size or regardless of its historical connections to the United States, can take more than a certain share of the visas that are available each year. 10% was the original structure, 10% in the law. No country can have more than 10%. But that doesn't preclude, for example, Mexico, China, India, the Philippines, and Cuba from taking 50%. And so it's a very, very small restriction, compared to what existed under the prior policy. And so in these terms, that a million in one day is not a huge influx. A 2% increase over a period of decades is not a huge influx. At least with respect to Asian Americans, Asian immigrants, there still has not been a huge influx. Compared to the proportion compared to the population of Asia as a proportion of world population, the percentage of Asians in the immigrant stream is small. 50% of the world population is Asian. 5% of the US population is Asian. It's still a small group, and it is still the case that the United States is a long way from becoming a distinctively Asian country. So, that's the basic background of my argument that the diversification of the immigrant stream was not an unintended consequence of Congress in 1965. It was one that they understood might well happen, and they did not stand in the way of. There are a number of ways in which the 1965 Act was imperfect. There are a number of ways in which people with legitimate claims to consideration by the United States were not accounted for. But I'm going to hold those for the moment and ask if anyone has any questions.
What was LBJ's role in the passage of the 65 Act in comparison to his vigorous role in the Civil Rights Act and the Voting Rights Act?
I think he supported it. He signed it in a ceremony at Liberty Island in the shadow of the Statue of Liberty in October of 1965. I do think that this was an act that there was more action. It was happening more in Congress than it was dictated by the administration.
A strategic question. I agree with the thrust of your talk, but did anyone ever say at the time, if you don't see this law as changing anything in reality, then why is it so important to pass it?
It's completely clear that there were geopolitical considerations as well. 1965, of course, is a war year, as 1952 and 1943 were, and there was a lot of discussion about how the remnants of the national origins quota system, particularly as they applied to the Third World, were used by communist propagandists. And so it's completely clear that geopolitics was a driver of the bill, as well as domestic politics and as principles of fairness and equality. But there were lots of people who said, as scare tactics, that there could be hundreds of millions of Chinese immigrating to the United States. One person said that, I can't remember the exact date, but one witness testified that by 2000 there might be 479 million Chinese in the United States. And in 1952, these sort of wild fears of racial invasion, 1943, 1882, the Yellow Peril arguments and the foreign invasion arguments worked to structure some kind of restriction, some kind of quotas. And by 1965, they had failed to do so.
I agree with you. My question was, surely someone might have asked the proponents, you're pushing, usually when you get new legislation that people are happy about, the proponents talk about all the wonderful things that will result. So here you have a paradox of this major legislation that its proponents say, often with a straight face, really won't change anything substantially.
Well, even Emanuel Seller and Dean Rusk and Mike Masaoka, they didn't say it's not going to change anything. They said in the context of a situation that's already changing, that the 1952 law's efforts at restriction had come undone with individual laws and special laws and waivers and exceptions, and so the Asian immigration, for example, was 10 times the quota. So the quota was 2,000 a year, and there was never a year when it was anything close to that between 1952 and 1965. And so what they said was, given that the efforts at restriction imagined by the 1952 law have already failed, the changes that follow on after that aren't going to be necessarily that much more significant. So nobody was saying it's going to stay just the same exactly as it is.
You mentioned that immigration from the Western Hemisphere wasn't limited after 1924, and then you also said that only white people could apply for naturalization until 1952. So were Latinos, Mexicans, and other Latins allowed to apply for naturalization before 1952?
Yes. So there's been some discussion at this conference of the implications of the 1790 Naturalization Act and its restriction of naturalization to white persons, and what do we do with Armenians, and what do we do with Arabs, and what do we do with Japanese, Mexicans, and Filipinos. And Mexicans had a tradition of being allowed to naturalize from the peace treaty after the Mexican-American War, and they were treated as white. And then, again, lots of details have changed over time, but in 1924, the Naturalization Act was extended to persons of races indigenous to the Western Hemisphere. So Mexicans have always been allowed to naturalize. At least in the reported cases, they've always been allowed to naturalize. Let it.
Engineers were privileged. I mean, did we need engineers, or was somebody in the House of Representatives in need of it? We need engineers, I think.
Yes. Well, at one point, there was a special bill to allow to give special immigration preferences to sheep herders, and oddly enough, Senator McCarran of Nevada was a sheep farmer, but I'm sure that's a total coincidence. But the 1962 law was, I think, responsive to legitimate demands in the economy and consistent with the idea that we want to allow people to immigrate to the United States who are going to make economic contributions to the country.
Again,
We're done?
We're done. Again, one of the marks of a great paper is that I have to cut off the questioning and answering.